खबर का रुख करते महाराष्ट्र में विधायकों की अयोग्यता पर बड़ा फैसला। विधानसभा स्पीकर का अयोग्यता पर बड़ा फैसला। स्पीकर राहुल नार्वेकर ने सुप्रीम कोर्ट के आदेश पर फैसला सुनाया है। इस वक्त का बड़ा अपडेट, विधानसभा स्पीकर का अयोग्यता पर बड़ा फैसला। महाराष्ट्र के 16 विधायकों पर
The defiance of whip with regards to the speaker's election. Group number 6 consists of petition number 21, again filed by legislator belonging to the UBT faction under 21B with regards to defiance of whip for the confidence motion. Group number 5 consists of petition number 22 to 24, which has been filed by legislator belonging to the Shinde faction under 21A and 21B. Group 2 consists of petition number 17, which has been filed against certain independents and members belonging to other parties under 2 subclause 2. So we shall, before I proceed with the judgment, pronouncement of the order, I would like to express my sincere gratitude towards the Honorable Supreme Court of India, which has provided an extremely guiding force by way of its order, whereby they have given a direction to the whole adjudication of the issues being decided in the proceedings today. Therefore, I would at the outset express my gratitude towards the Apex Court. At the same time, I would like to express acknowledgement and a big thank you to the staff of the state legislature who have assisted me and the paralegal assistance which I have received from them during the course of the conduct of these proceedings pertaining to disqualification. I would also like to appreciate the cooperation which I have got from counsels appearing on both the sides, and I shall now proceed with the pronouncement of the order. As we are aware that there are certain preliminary issues which are applicable to all the 5 groups out of the 6 groups, and therefore I shall first commence with my ruling on the preliminary issues which concern all the 5 groups. Thereafter I shall pronounce the operative part of the orders concerning each group and the relevant and important paragraphs pertaining to each group. So we shall commence with group number 1. Preliminary issues. The Honorable Supreme Court in Subhash Desai Supra versus the Governor of Maharashtra, hereinafter referred to as Subhash Desai, was pleased to direct that the Speaker should prima facie determine who the real political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly shall recognize the whip and the leader who were duly authorized by the Shiv Sena political party, keeping with the principles discussed in the said judgment. Hence, keeping in view the factual matrix and the directions of the Honorable Supreme Court, I will prima facie determine who the political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly recognize the whip and the leader who are duly authorized by Shiv Sena political party. Keeping in mind principles discussed in Subhash Desai Supra, it is necessary to consider and determine the said preliminary issue before examining the merits and deciding whether respondents have incurred disqualification under the 10th schedule of the Constitution of India. Thus, the preliminary issue that arises for my consideration Before delving into the merits of disqualification petitions under the 10th schedule is, which among the two fractions was the real Shiv Sena political party, and consequently, who was the duly authorized leader and or the whip of Shiv Sena political party for the purpose of deciding the present disqualification petition. The other issue framed for my consideration in this group of disqualification petition is whether the respondents have incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution of India on account of their alleged acts and conduct. Paragraph 84 deals with the principles which have been laid down by the Honorable Supreme Court. I am not going to read out those are a part of my order. I'll come to paragraph number 85 now. Thus, what emerges from the principles laid down by the Honorable Apex Court in that the question of who the real political party is has to be considered and determined after giving due weightage to 1. The Constitution of Shiv Sena, 2. The leadership structure of the party, and 3. The legislative majority if two or more factions claim to be real political party. The question of who the real political party is hereinafter referred to as the preliminary issue. Since in these proceedings both in the previous paragraphs I have recorded the submissions made by both the parties. I will come down to my observations and conclusions with regards to the preliminary issues. As stated earlier, the decision of the preliminary issue has to be taken after careful analysis of the Constitution of Shiv Sena, the leadership structure of the party, and the legislative party majority. After having heard both sides on the above aspect, I now propose to proceed to record my observations and finding on the preliminary issue. As is evident from the submissions of the parties, there is no consensus on the Constitution submitted to the Election Commission of India with consent of both the factions. Likewise, the parties have different point of view on the leadership structure, which has to be taken into consideration. The only aspect which is undisputed is the majority in the legislature party. Hence, to embark upon the finding on the preliminary issue, I will have to decide the relevant constitution which has to be taken into account. 2. The leadership structure which existed before the dispute arose. Further, it will also have to be determined as to when the rival factions emerged. Petitioner's assertion that the Constitution of the year 2018 is the relevant constitution which has to be taken into account for the purpose of determining the preliminary issue is based on the submission that 1. The 2018 Constitution has to be considered as both the parties have relied upon the 2018 amended Constitution and acted thereupon. 2. The Election Commission in its order dated 17/2/2023 in dispute case number 1 of 2022 has held that both the parties were aware of the 2018 amendment, and thus the said Constitution of 2018 has to be taken as the Constitution which is done with the consent of both the factions, as the said Constitution of 2018 was never disputed prior to the initiation of these disqualification petitions, and the same was never challenged. 3. Respondents have themselves admitted and relied on the said Constitution of 2018. And 4. The statement of Sri Yogesh Kadam that the filing of 2018 Constitution along with the respondent's reply was a mistake done by the lawyers cannot be accepted, as the said statement is an afterthought and done only with the intention to mitigate the damaging statements made by Sri Dilip Lande. To the contrary, respondents have asserted that the Constitution of the year 1999 has to be the one which has to be borne in mind, as according to the respondents, the Constitution of the year 2018 was never submitted to the ECI. Respondents pointed out to the letter dated 4th April 2018 by way of which the petitioner based their claims of submissions of the said constitution to the ECI. By pointing out to the same, respondent submitted that both the said letters do not mention anything about the purported amendments to the constitution or submission of the same thereof to the ECI. A similar claim was made with respect to the letter dated 27/2/2018 by Shri Uddhav Thackeray in the special leave petition number 3997 of 2022. However, in the said SLP, there was no mention about the existence of any such letter dated 4th April 2018. The word submitted appearing in paragraph 168 of Subhash Desai means submitted before the ECI, as is evident from the further part of the said paragraph, which the petitioner has conveniently ignored. The respondents have further submitted that 2018 Constitution has been wrongly annexed as a document. The stand of the respondent on the 2018 Constitution has always been that it is unconstitutional and was secretly manufactured by Shri Uddhav Thackeray in cahoots with Mr. Anil Desai. This stand has been specifically taken in the reply filed by Shri Eknath Shinde before the Honorable Supreme Court in SLP number 3997 of 2023, way back on 16/3/2023, much before filing of the replies before the Speaker in August 2023. Further, even the additional replies filed on 25/10/2023 in the present proceedings, the aforesaid petition has been reiterated by the respondents. After having considered the submissions advanced by both the parties on the question as to which is the relevant constitution for the purpose of determination of the preliminary issue, I have come to the following conclusion. A. As per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that pursuant to the initiation of these disqualifications, the Maharashtra Legislature Secretariat had vide letter dated 7 June 2023 requested the Office of the Election Commission of India to provide a copy of the party constitution / memorandum / rules and regulations The Election Commission of India, with a letter dated 22nd June 2023, provided a copy of the Constitution and rules of Shiv Sena as available on the record of Election Commission of India. Further, with respect to amendments, if any, to the said Constitution of the party, the Election Commission requested the Legislature Secretariat to refer to the order dated 17 February 2023, passed by the ECI in dispute case number 1 of 2022. Having perused the same, it has to be noted that the copy of the Constitution of Shiv Sena provided by the ECI does not bear any date or year, but as per the ECI, that which is provided vide the reply is the only Constitution of Shiv Sena available on the record of the ECI. Further, with respect to the amendments, if any, to the said Constitution, the Election Commission, vide its order dated 17 February 2023, has held in paragraph 132 4b that the amended Constitution of 2018 is not on the record of the Commission. Thus, the petitioner's submission that the Constitution of the year 2018 has to be taken into account cannot be accepted, as I am bound to follow the directions of the Honorable Apex Court in Subhash Desai Supra, and accordingly take into account the Constitution which the Election Commission has provided. In my jurisdiction under the 10th schedule of the Constitution of India, I cannot delve into any other factor while deciding which is the relevant constitution. As prima facie, it is evident from the records of the ACI that the 1999 Constitution is the one which was submitted to the ECI by the Shiv Sena before rival factions emerged. Further, it is also necessary to mention that the petitioner's submission that the constitution of the year 2018 was submitted to the ECI by referring to the letter dated 4th April 2018 cannot be accepted. A bare perusal of the said letter dated 4th April 2018, by way of which the petitioner based their claim of submission of the said constitution to the ECI, does not bear any content which shows that an amended constitution was submitted to the ECI. The said letter only refers to the election held and the results thereof, and nothing more. Further, on closer examination of the special leave petition filed by Mr. Uddhav Thackeray before the Honorable Supreme Court, challenging the ECI decision SLP number 3997 of 2022, I find that exactly same claim has been made about the letter dated 27/2/2018, and there is no mention about the new letter of 4th April 2018. Accordingly, said letter of 2/7/2018 is on the website of the Election Commission of India. However, there is no document relating to the constitution annexed to it. Hence, on this ground also, petitioner's submission that the constitution of the year 2018 has to be taken into account cannot be accepted. Petitioner's submission that submitted before the speaker, petitioner's submission that into inverted submitted before the speaker would mean into inverted annexed by the petitioner and the respondents in their respective petitions and replies thereto cannot be accepted, as there is a clear provision under the 1986 rule where the leader has to submit the party constitution. Rule 3 subclause 1 subclause B of 1986 rule mandates that the leader into inverted shall furnish into inverted a copy of the rules and regulations, whether known as such or as constitution or any other name, of the political party concerned. Further, Rule 3 subclause 4 contemplates that whenever any change takes place in the information furnished by the leader of the legislature party under Rule 3 subclause 1, he shall as soon as may be thereafter, and in any case within 30 days from the date on which such change has taken place, or written such further period, or within such further period as the speaker may for sufficient cause allow, furnish in writing information to the speaker with respect to such change. Thus, the submission of constitution before the speaker has to mean submission under Rule 3 of 1986 rules. However, till date, Shiv Sena has not submitted any constitution on the record of the speakers of the speaker under the said Rule 3. In view of the above observation and finding, I need not further analyze any other submission in this regard made by the parties, and I hold that the constitution of Shiv Sena provided by Election Commission of India, vide letter dated 22nd June 2023, is the relevant constitution of Shiv Sena for determination of the preliminary issue as to which faction is the real political party. Constitution of Shiv Sena held to be the relevant constitution is hereinafter referred to as the SS Constitution. The leadership structure relevant for the determination. Learned Senior Advocate Mr. Kamath's submission that the leadership structure which is relevant for the purpose of deciding the preliminary issue is the leadership structure which is reflected in the communication dated 27 February 2018 and 4th April 2018 made to the Election Commission of India pursuant to the elections held on 23rd January 2018 is based on the petitioner's submission recorded in paragraph 89A to G herein above. Initially, the petitioner relied on the affidavit submitted to the ECI of the then office bearers of Shiv Sena produced along with the affidavit in lieu of examination of chief to show that Shri Uddhav Thackeray had support of the majority in the organization. Respondents objected to such production on the ground that it is not permissible to produce affidavits of others along with petitioner's own affidavit in lieu of chief examination without the author of the said affidavits subjecting themselves to cross-examination. In any event, during the arguments, Mr. Kamath did not rely on these affidavits and limited his submissions to the 2018 leadership structure as available on the ECI website. Mr. Jethmalani, in turn, focused his submission to buttress the ground that the said leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of Shiv Sena, which is on record of the ECI, and thus the same would be contrary to the findings of the Honorable Supreme Court in paragraph 168 of Subhash Desai. Mr. Jethmalani further relied on the legislative party leadership to submit that the legislative party also forms part of the leadership structure, as it is not only mentioned in the SS Constitution, but there is no dispute regarding the said members being part of the Pratinidhi Sabha under the SS Constitution. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure for the purpose of determination of the preliminary issue, I have come to the following conclusion. The submission of Mr. Kamath, the jurisdiction under the 10th schedule, only mandates a prima facie adjudication as to what the leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not the leadership structure available on the record of the ECI was pursuant to a validly held election, is a correct position, and hence I concur with the same. Petitioner's submission that in these proceedings the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct position, and hence I am in agreement with the same. Respondent submission that the leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of Shiv Sena, which is on record of the ECI, does not arise at this juncture, as it is a submission which has to be considered while determining whether the said leadership structure can be relied upon for the purpose of determining which faction represents the real political party, which would be dealt with at the appropriate juncture. The only question which is to be determined in the current part of the order is what and who all constituted leadership structure of Shiv Sena at the relevant time. Respondents have led detailed evidence, and despite being confronted during cross-examinations, they have been able to demonstrate that no organizational elections were held on 23/1/2018. On the contrary, in the affidavit in lieu of examination of Chief of Shri Sunil Prabhu, PW1, has stated that organizational elections were held on 23/1/2013 and 23/1/2018. However, Shri Sunil Prabhu has not claimed any personal knowledge of the same or and whether he was present during the said elections. During his cross-examination, he was confronted with the letter dated 28/1/2013. Thereafter, a specific question was posed to him by Mr. Jethmalani as to whether he voted in the said election, to which he responded in the affirmative. The contents of the said letter clearly stated that all the candidates were declared unopposed. The contradiction was also put to the witness by Mr. Jethmalani in cross-examination. However, no justification for the same was put forth by the witness. In view of the above evidence and records before me, prima facie indicate that no elections were held in the year 2013 as well as in the year 2018. However, I, as the Speaker, exercising jurisdiction under the 10th schedule, has a limited jurisdiction and cannot go beyond the record of the ECI as available on the website, and hence I have not considered this aspect while determining the relevant leadership structure. Thus, in view of the above conclusions, I find that the leadership structure of Shiv Sena reflected in the letter dated 27 February 2018 available on the website of the ECI is the relevant leadership structure which has to be taken into account for the purpose of determining which faction is the real political party. The question whether which faction is the real political party is discernible from this 2018 leadership structure is discussed in paragraph 112 to 131 infra of the present order. The leadership structure so determined as the relevant leadership structure for the purpose of these disqualification petitions are hereinafter referred to as the 2018 leadership structure. Since in these proceedings both the factions are claiming to be the real political party, rival factions have emerged in the Shiv Sena. In view of the fact that rival factions have emerged and both the factions are claiming to be the real political party, it is imperative to prima facie determine when did the rival factions emerge. Thus, it is necessary to determine the relevant day on which rival factions emerged before further venturing into which of the faction was the real political party when rival factions emerged. At the outset, I must set straight the point that the determination of the Speaker exercising jurisdiction under the 10th schedule while deciding who the real political party is mandates only a preliminary inquiry which has to be done prima facie by taking into account material officially before the Speaker as the Master of the Legislative Assembly. I shall consider the facts relevant for the determination on what is before me as the Speaker of the Legislative Assembly. As noted by the Honorable Supreme Court in Subhash Desai Supra, on 21st June 2022, there was no material available before the Deputy Speaker to infer the emergence of any rival faction. However, after taking on record the resolution dated 21st June 2022 passed by the SSLP, disputed by the respondents, the very next day the then Deputy Speaker received a resolution disputed by the petitioner dated 21st June 2022, received by the then Deputy Speaker on 22nd June 2022, contrary to the resolution dated 21st June 2022. Thus, from this fact alone, it is evident that there emerged two factions of the Shiv Sena from 21st June 2022 itself, but the same came to be officially on record of the office of the Speaker and or Legislative Secretariat on 22nd June 2022. At this juncture, it is imperative to refer to paragraph 119 of Subhash Desai Supra, where the Honorable Apex Court, while discussing the legality of the recognition of leader and the whip of Shiv Sena, accorded by the letter dated 3rd July 2022, held that the Speaker ought to have taken into consideration the split that took place within the Shiv Sena, which were discernible from two sets of resolutions appointing two different leaders and whips placed on the record by Shiv Sena before the Legislature Secretariat. This paragraph into bracket 119 read with Honorable Apex Court's finding recorded by the Honorable Apex Court in paragraph 157 of Subhash Desai Supra makes it clear that the law laid down by the Honorable Supreme Court is that in view of the deletion of paragraph 3 of the 10th schedule, when rival factions emerge as a result of rift/split in the party, the Speaker has to necessarily find which faction is the real political party while recognizing leader and the whip of the party. Thus, in view of the facts recorded in the preceding paragraphs and keeping in view the principles enumerated by the Honorable Supreme Court in Subhash Desai Supra as recorded in paragraph 84 herein above, I have come to the following conclusion that the emergence of the two factions of Shiv Sena can be inferred from 21st June 2022 itself, and the same came to be a matter of official record of the office of the Speaker and or the Legislature Secretariat on 22nd June 2022. Conclusion, having decided the 1. Relevant constitution of Shiv Sena, 2. Leadership structure, and 3. The relevant point of the relevant point for the purpose of determining the preliminary issue, I have made the following analysis, observations and determinations on the preliminary issue of which faction was the real political party when two factions emerged. For the purpose of analyzing, discussing and determining the issue, the faction of the petitioner is hereinafter referred to as UBT faction, and likewise the respondent's faction is referred to as the Shinde faction. The applicability of the test of aims and objectives. I am not going into the details of reading the applicability of the test of aims and objectives, because as you are aware that in accordance with the directions of the Apex Court and otherwise, the speaker is not required to get into the political thicket with regards to the aims and objectives of a political party. So I am restricting it to pronouncement, and you can have a look at it once you apply for the certified copy. The reason why Shiv Sena constitution assumes significance is to analyze whether the question of which faction is the real political party is discernible from the leadership structure identifiable from the said Shiv Sena constitution. So the Shiv Sena constitution is relevant to the extent of identifying the leadership structure. Leadership structure as a criteria to determine who was the real political party. As I have already held, which is the relevant constitution and the leadership structure of the Shiv Sena to be taken into account for deciding the preliminary issue, I now have to see whether the relevant leadership structure read with the SS constitution provides answers to the question which faction is the real political party, and consequently determine the same. The UBT faction made, there are submissions made which have been recorded of both the sides, which are at paragraph 113 and 114 of my order. In view of the above recorded submissions of the parties, there emerges two further questions: whether 2018 leadership structure is in conformity with the constitution of Shiv Sena. Number two, whether will all the Paksha Pramukh whether will of the Paksha Pramukh and or majority leaders in the 2018 leadership structure could be said to be synonymous with the will of the political party. So we further have to derive two more, again, answers to two more questions. The primary one being whether 2018 leadership structure is in conformity as provided by the constitution, and number two, whether the will of the Paksha Pramukh and or majority of the leaders reflects the will of the political party. As there are contrasting submissions on the question, it is necessary to peruse the SS constitution and the 2018 leadership structure and then record a finding as to whether the 2018 leadership structure is in conformity with the constitution of the Shiv Sena. Thus, I have taken a comparative look at the 2018 leadership structure and the Shiv SS constitution and have arrived at the following observations and conclusions. A. 2018 leadership structure mentions Shiv Sena Paksha Pramukh into bracket president as the highest office of the SSPP. However, in the SS constitution, the highest office of the Shiv Sena political